Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everyone? Hello, Dean Walker. Glad you made it. Hello, Texas Brad. Hello, Eva. Hello, Doris. There was a hearing, hi, B Rabbit. There was a hearing today in Karen Reed's civil case. So this is after Karen Reed was acquitted of the most serious charges in her case. We've been through the reasons why that happened probably a zillion times. As I feared, her innocence fraud campaign was allowed to come into the courtroom. And I mean, it was almost literally, you could hear the screams of the football-sized crowd outside as the jury read the verdict and as they were deliberating. It was just there was just no difference from the court of public opinion and the court, I mean, had just totally merged in that case. Now we have this civil case where Karen Reed is being sued by the man she's accused of running over and killing with her car and leaving to die in the cold, John O'Keefe. Her family is suing for wrongful death and pain and suffering for Kaylee, who was the older niece. So there's a niece and a nephew. Patrick is the younger son of John O'Keefe's sister, who tragically died of cancer, and her husband died of a heart attack after. So she's been orphaned 3 times in her life, all before the age of 18. She's suing Karen Reed for pain and suffering. But the big news today, and this is something that I had been predicting because it is the innocence fraud playbook, and Karen Reed has really followed that innocence fraud playbook, which is you sue civilly for wrongful imprisonment, wrongful arrest, and you get these big multi-million-dollar payouts. Basically, you sue whoever you can that you think you can get money out of. And so she's suing the police department for not training correctly. And often the police departments are covered by insurance for these kinds of lawsuits and will pay out and think it'll cost us more to fight it than it will. It costs us more to fight it than just pay it out. So they think they're saving time and money by paying it out. But this is a movement. They're like pigeons. They just always come back for more. So what that does is that opens up the door to everyone who's been arrested and charged, arrested by the police and charged and been acquitted in this area of Massachusetts to sue for not correctly training their officers. Because I guess Michael Proctor had some mean texts about Karen Reed while he was investigating, let emotions get the best of him because he's investigating the case and all roads lead to Karen Reed. If you follow the evidence, they do. I mean, for those who think it was a 50-plus conspiracy, the car, Karen Reed's car with her smashed to smithereens taillight, was already on the way to the Sally Port when the CERT team arrived. So there was no time to plan evidence. They were finding pieces of her taillight. It doesn't make any sense. But it continues to go on, and Karen Reed had supporters there in the courtroom. We're going to look at it. She brought 7 lawyers. Let me see. Let me look at my notes for a second. And so they are from the firm of Mellick and Porter, Sheehan Finney is the other main, and then there's Alan Jackson's law firm. So Alan Jackson was there. So 7 lawyers from 3 different firms. It was quite something. They couldn't all fit at the table. Karen Reed had to sit in the gallery with her lawyers. I mean, this reminded me of going to Keith Raniere, the Nexium Gurus hearing, and I said they have to get a bigger boat like Jaws. They have to get a bigger courtroom or a bigger defense table. So she's the defendant, and in this case, she's facing the plaintiffs. This is a civil case. So what's on the line is money. That's how our civil courts work. Who's going to pay? And they're suing for money, but more than that, they're really suing for accountability, to hold her accountable. And I'll get into why I think Karen Reed is suing in a minute. It's not just for the money, although that is part of it. There's a much bigger idea behind this. So there's a shot of Alan Jackson. So let's get into it.
Counsel, I asked the question that you asked, Counsel. He would like to.
Sorry, I'm ahead. I moved. I thought I just got into this. I thought that was just the beginning. There we go. It was just the beginning.
Counsel, I asked the question that you asked, Counsel. He would like to do status first, then the Rule 12s, but he also said to me if you could check your calendars for trial date. All right. Ms. Craig, are we good to go?
So why is this is the why do we have the guy who did the exhibitions at the trial? Why is he here? He's back from the criminal trial.
You let us know we're ready.
So the Reeds were in the gallery. John O'Keefe's mother was there, Peggy O'Keefe. And of course, Paul O'Keefe, John O'Keefe's brother.
All right.
Good afternoon, folks. Good
afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well, thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Okay, good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed. Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Erin Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay,
Good
good
afternoon,
afternoon.
Your Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Bar and Grill.
I'm sorry.
Right. And they're also suing the Waterfall Bar and Grill for over-serving Karen Reed.
The waterfall?
Waterfall, yes.
Got it.
Good afternoon, Your Honor. Karen Reed also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Lincoln Rose on behalf of the defendant, CF McCarthy.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues.
So what Karen Reed is saying is they're saying because Kaylee, who was woken up by Karen Reed very early in the morning, because she was woken up and shook by Karen Reed and told that John O'Keefe was missing, and she didn't know where he was. She pretended to not know where he was. That because she didn't watch him get run over by Karen Reed, that she's not entitled, that they're pain and suffering. So that she wasn't really traumatized. That Karen Reed, who already knew this, and hold on one second, Mark Diller makes a very good argument later on in this hearing as to why those charges should move forward and let at least have a jury decide whether she deserves any money for pain and suffering and for re-traumatizing her. But I mean, Karen Reed knew that her mother had died of cancer and that she had lost her father just months later of a heart attack. So they're saying because she didn't witness it with her own eyes, but they've also, so get ready, this is when Karen Reed's legal team just drops this idea that Karen Reed's going to sue everybody without ever filing it, because this is what they did in the criminal case. They like to sandbag the prosecution. So now they're sandbagging the plaintiff's team in this case. So what they would do is they would not hand over any discovery and just sandbag them and say, well, we're going to put on a witness, but you don't know what they're really going to talk about. I mean, if the prosecution had done that, it would be Brady violation, acquittal, and then lawsuits over it. I mean, just wild. It could have stopped her own case if the prosecution had did it, but because the defense did it, they got sanctioned by the court with just with a talking to by the judge. But it could have been much worse. I mean, that was just one thing. The other discovery things, they talked on encrypted apps with their expert witnesses so that the prosecution wouldn't have any of that material. wouldn't know what they had done or what tests had done or if they were handing over everything fully. I mean, this was just such a manipulation of the courts. It's really wild. So here's where they're going to drop it. So this is one of the reasons that they decided to drop it like this, because this is going to rile up all the free Karen readers out there and get them to start donating to her defense fund and riled up and excited, and that they want to marry. So Karen Reed, it's also a distraction technique. Karen Reed is going to be saying that she's really the victim and that she's suing all these people, and it will take the heat off of her and distract the jury. As Hank Brennan said, look over their technique that she's always used. So that's another reason why it's not only rile up her base with this, just dropping this on the court with no official filing. So they wrote nothing. They just came in and announced it in court. It's really quite outrageous. As lawyers, they know they can't do that. But I mean, the judge can't rule on something he doesn't see the argument for. They just orally argue that it's going to streamline things to bring in Karen Reed's lawsuits against all these people. But what it's going to do is it's going to make a third-party culprit kind of defense for her. It's going to make a distraction defense for her. And again, make her the focal point. All the people like, oh, you think I ran over my boyfriend? But look at what the police did to me. Look at what these people, look at their weaknesses, their human frailties. Maybe they did it. This has always been her technique. The look away, because she can't really defend herself against any of the serious evidence. It's always like, look away. Maybe Proctor did it. Maybe Jen McCabe did it. Maybe someone else did it. Anyone but Karen Reed did it.
That you see in the case for now, we can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are, it is significant.
So they're waiting to get these filings, all the evidence from the DA's office. I would have thought these lawyers would have been at the courthouse the minute the criminal trial ended to receive the documents, get them in person. What are they doing waiting for the DA to send them the documents? This doesn't make me feel good about this plaintiff's team here for the O'Keefes. They really should have been proactive and been working for months on getting these things, because as soon as they can get these documents, they can start deposing people, including Karen Reed in this case.
Deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted.
Okay. Wonky? Does this sound okay? Dean Walker, thanks so much for the super sticker. Really appreciate you, especially supporting these smaller shows. It is not easy telling, having this opinion. This is certainly not the money side of YouTube. I appreciate it, Dean Walker. Weird static? Okay. You're getting weird static? Hold on one second. Let me fix it. Please hold. Should I take a break? I'm going to take a break and fix my mic. Okay.
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact focused queen busting propaganda schemes. Glass shatter lies echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light. Hard cash warrior, dissecting state and defense. Twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims, her creed, justice till the end. Headphones blazing, she drops heavy artillery. Narratives twisted, meet blunt object civility. Roberta got receipts that unravel the ploy. Exposing the lies these fraudsters deploy. Glass shatters lies, echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light.
Okay, is that better? I hope that's better. Hold on one second. Sometimes it's a live show and sometimes these things happen. Let us see. Sound good? Okay, lovely. Let us continue. So what he's saying is this is, again, you're just tuning in. We're watching this civil hearing, Karen Reed's civil case, the O'Keefe's against Karen Reed. She's about to drop a bomb on the plaintiffs, saying that she's going to sue for everything. But Mark Diller, this is representing the O'Keefe's, is saying here that they haven't gotten hardly any discovery yet from the DA's office.
All discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions or no?
Only one deposition has been noticed and it's been tabled because we don't have any documents at this stage.
Right. They can't do the they can't do the depositions because they don't have the documents. Why they didn't start asking for this stuff, having it at the ready the minute the criminal trial was over, I don't understand. This lawsuit came about as Karen Reed's criminal trial was ongoing. And this judge decided that they could not depose Karen Reed, which would have been great if they'd given the okay until after her criminal case was over. I mean, that means that whatever she had deposed in the civil case, they could have used in the criminal. So essentially, Karen Reed would have testified unwillingly She could have just taken the
I
fifth.
see. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy.
So Karen Reed's rights were violated, she says, in her arrest. So she doesn't have to prove any of these cases, right? She just has to make it 51% more likely that her rights were violated than not. And why I predicted that she was going to sue civilly for all these things, this is the way innocence fraud cases go all over America. If you can get a convicted killer out, hook or crook, and get their conviction reversed, then they sue civilly and get these big multi-million-dollar payouts. And it also cements the idea, what Karen Reed wants to do is cement this as American myth, that this was some kind of 50-plus police conspiracy instead of Karen Reed really being the end of a domestic violence relationship running over John O'Keefe. John O'Keefe had asked her in the days before to move out, and she refused. In the days and weeks before she murdered him, to move out, and she wouldn't. So many people, including myself, think they had this final argument where he said he was telling her, according to Kaylee, the niece, that the relationship had run its course. So this was the final middle finger to John O'Keefe. And even Karen Reed says that to think this wasn't a planned thing is a mistake. And whether she had been thinking about it, the plan was to teach John O'Keefe a lesson, is to really hurt him physically the way, he hurt her ego by leaving her. It's about power and control, like every single other one of these cases. So here's where they're dropping. They're going to charge violation of rights. Forgotten that one, kind of hilarious. All of Karen Reed's civil rights were violated. Why, I don't know.
See, the claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers.
Right, they didn't train their police well enough. And I would think many of these lawyers are working pro bono just for the advertisement and to be in a high profile case. And of course, the money is nice too. If they win any of these, I mean, there's no punishment for bringing frivolous civil cases. Only things on the line is money.
We also intend, Your Honor, to bring affirmative claims against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reid's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reid in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court.
Right. So the judge later calls this a novel approach. I'm hoping he won't let this happen. I mean, if he lets this happen, this is going to be a madhouse. Another kangaroo court that Karen Reid can totally manipulate. He says she can't defend herself without pointing the finger at everyone else. Strange, huh? What other innocent person can't win their case without pointing the finger at everyone else?
Court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be
This is to streamline. If this judge falls for this, we have another Canoni on our hands. And Canoni has moved from the criminal courts down to the civil courts. A little bit of a demotion there. I mean, you could say it's a different. It's certainly not. I don't know. I consider it a demotion.
The individuals in the house diverted attention away from themselves towards Ms. Reid, that law enforcement then.
Right. They're saying they diverted attention away from themselves to Ms. Reid. They're telling on themselves. This is exactly what Karen Reid's doing. She's diverting attention away from herself and her actions and onto all these other people. I mean, she couldn't even develop a third-party culprit, but now in the civil case, she wants to throw in all these other people. It will be a nightmare. I mean, they've lost the case. They might as well. I mean, if this gets brought in, the plaintiffs in this case, Mark Diller and Dan Buck, they've lost the case if this gets brought in. Sounds like it's going to be hard to bring in, but could happen.
Acting on that diverted attention away from her, because the people in the house were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reid was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims.
Right. So he wants to streamline it. I'm not going to play any more of that. You get the point. Then I thought they ask for, they make an argument here to dismiss the charges, including the Waterfalls lawyer comes in on this too, against Kaylee. And this is when we get a long speech from Diller. And I thought this is where I hope I'm at the right place, where I thought it got pretty interesting.
The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving two young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost two parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost two parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family.
So at 4:30 in the morning, a little after 4:30, is when Kaylee said she's awoken by Karen Reed coming into her bedroom, and first she just shook her. And then around 4:35, Karen Reed retrieved John O'Keefe's niece's cell phone from John O'Keefe's bedroom, because she had so much trust. They had such a good relationship that even when she knew John O'Keefe wasn't going to be there to make sure she did it, he had a rule that she put her phone when she was going to bed in his room to charge, so she didn't have her phone at night. And Karen Reed brings Kaylee, the phone to her, and starts calling, and starts insisting she call other people. She's making her own phone calls, many to Michael Cameron.
Learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits.
This is more the kind of argument I wish we had in criminal court. I wish her public disinformation campaign came in, and the way that she immediately she didn't go to her home. She snuck into John O'Keefe's home, uninvited, and started plotting out how she was going to get away with her murder.
Her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not.
I thought that was ridiculous too. Texas Brad is asking, when is Natalie Bernschneider-Ruwicki, who was the middle woman between Turtle Boy and Karen Reed, going to be brought in? She was on the witness list for the prosecution, never brought in. It's like, I don't really understand the strategy. I always thought that you can't separate Karen Reed's innocence fraud campaign from her murder of John O'Keefe. I mean, it's like, so to me, it shows consciousness of guilt. The way, I mean, and he says, like, he lists all the places in this that she's talked to. And she never, I mean, this will go on for 20 plus years. This is now her new identity, being a victim of the Massachusetts State Police and justice system. And she's going to, like Amanda Knox, going to promote herself as a victim forever. It's never going to end.
Not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not.
Right. They're saying because Karen Reed didn't run him over in front of her family, that they can't sue for emotional distress. I mean, it's so ridiculous.
Not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs.
Right. I don't know. I mean, I think all these lawyers know about innocence fraud, but they don't know how to fight it correctly. So Karen Reed, everything positive about her innocence fraud campaign was allowed to be brought into the courtroom. Crowds were essentially just like invited in, into the jury deliberation room, and none of her scheming was ever exposed. I mean, how that jury was picked is another thing. I don't understand. I think Hank Brennan had lots of experience in picking a defense jury and not a lot of recent experience picking a jury for the prosecution. I think he subliminally picked a defense jury. I mean, it could have been more of the wrong kind of characters. Right, Roberta, so much was left on the table, right? I'll never understand. I mean, we never hear all of the truth in a criminal case. It's just an edited version. But when you're dealing with an innocence fraud campaign that's come into the courtroom, every little detail matters. Every little detail matters, and it tells the full story. And what innocence fraud campaigns do so well is they make them just really broad and vague. I mean, if anybody tuned into my episode talking about Amanda Knox, there's a moment in her interview with Gwyneth Paltrow, just went over it. And I really recommend true crime podcasts, 4-part takedown of that interview. There's so much good information in it. The link is in my posts on YouTube, my message board kind of thing on YouTube. The link to that. But what Amanda Knox is asked about the evidence, like, well, why were you picked if this was so unfair? Why did they think you did it? Basically, what's the evidence against you? Why were you convicted of this essentially twice? And then the court that let her go said that she was there at the scene and washed the victim's blood off her hands. Never mind that. But even without knowing that, and that's when Amanda Knox gets really vague. Like, I don't know. I don't know why. They said I smelled of sex once. That's why. Really? Well, that's kind of hard to put in front of a bunch of judges. Excuse me, Your Honor, she smells of sex, therefore she must be guilty of murder. No, it doesn't work. So he's got to, you got to really bring in the whole story, and the whole story includes Karen Reed's cover-up. I thought it was going to go well in the criminal case when Hank Brennan started talking about a cover-up, but he would start a lot of things and not finish them.
And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendant.
Alan Jackson looked so jet-lagged and just out of it in court, like he's not even listening. He's like, I've done my job. My job was to bring all these civil charges against all these, just be here when they announced all these civil charges that they're going to file against all these other people, and see if the judge buys that. I don't have to make any arguments, and he doesn't make any arguments.
Also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose...
Right. I mean, they're essentially saying, Karen Reed's defense is essentially saying, because Karen Reed hid this all night and sat on it from when she ran John O'Keefe over a little 12:30, little after 12:30 a.m., that because she said nothing and plotted how to get away with it, that the O'Keefe family couldn't, because they didn't see her do it, that they couldn't be traumatized. I mean, this is absurd.
Of the law.
I mean, they had to wait for Karen Reed to notify them, because Karen Reed didn't notify them at the time.
Is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that.
Right, because Karen Reed brought all these people into it to start mixing it up. There was no need. She never called 911. She never called for actual help. It was all getting other characters involved to absolve, to be able to point the finger elsewhere later, to create chaos, to create confusion, to point the finger away from herself. So she brings Kaylee in to help solve this mystery of John O'Keefe. Something, the only person that knew that something terrible had happened to him was Karen Reed. And why her supporters can't understand that, and why the jury didn't get that. I mean, I think they just basically nullified it, felt the public pressure, and hated the police, and was just decided to give the big middle finger to the police and the man by letting Karen Reed walk. But everybody else who's lived on planet Earth knows that when you're not calling for help and you're not doing logical things, right, it looks very suspect. If you think something's happened to your boyfriend, right, and you're worried he didn't, first, she never looked for him. When she said she pretended that he was lost, she never really looked for him. She pretended to look for him. And then she called up her first person she wanted to get was the Cameranos, because she knew that they would, by the way they, look at the way they testified for her. They were essentially testifying for the prosecution. Michael Camerano weakly said that John O'Keefe was angry because Karen Reed was late coming out because she said she was waiting for a plumber. When she ever got that plumbing and that rusty pipe fixed, or if she ever did call the plumber, or if this was just another lie told by Karen Reed to piss John O'Keefe off, and it worked. John O'Keefe told Michael Camerano he was pissed off that Karen Reed hadn't asked her, so dad's a plumber, him and his dad, to fix her plumbing. But it seems, if you look at the text messages between Karen Reed, it seems pretty apparent that it's another one of Karen Reed's tactics to get power and control over John, get him involved with her, rile him up.
Second, we also suggest that you should deny it because they experienced the injuries closely on the heels of them being knowable.
I mean, this was never really prosecuted. It really should have been prosecuted as a DV case. If Karen Reed were a man, that's exactly how it would be prosecuted. And the same facts were in evidence, that they fought all day via text message, that they had been fighting, that she tried to kick this man out of her home, and a man ran over his girlfriend and left her to die in the snow. We'd all be talking about it like it was a DV case, because that's exactly what the facts, the evidence shows. But because it's a woman, can't possibly be abusing a man psychologically. It's unfortunate. I hope this changes.
And perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs.
The thing that's helpful is that she's been convicted of drunk driving. She was driving drunk. She should have known by backing up at that great rate of speeds, that she could have caused his death. Kitties, thanks so much. I really appreciate your support. They are threatening to recreate the trial circus. Yeah, do we know the judge's record? We don't. Right, it's in Plymouth County. My understanding, about 45 minutes, an hour away from Canton. Tomorrow, I'm going to be speaking with Brendan Kane, who's John O'Keefe's friend. about this hearing. He attended this hearing. So I'm not sure. Do you guys have questions for him? Do you want that to be a live show? I'm trying to figure out if I should do it live, or would you prefer a more tightened tape show? Let me know. I don't know. It's not going to be at the same time. If it's going to be live, it's going to be early in the morning. So,
And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct.
all right. Okay. I mean, some of this is case law mixed in with some really good zingers at Karen Reed. Is the judge later? He calls this a novel approach at one point, and then he gives a long speech here about how they should settle and how this could go on for years, that he has one case that's 18 years old. And Karen Reed will never settle. She will let this go on as long as she can continue to re-victimize the O'Keefe family and continue to gain power through the courts. I mean, she's gone from strength to strength to strength. She sold her rights, her book rights, her movie rights. Most of these lawyers, I believe, are working pro bono. She's not losing any money on this. Anything that she spends on lawyers, her fans, her murderer groupies will pick up the tab for. So she doesn't have much to lose. But the idea that they'd settle, I think the O'Keefes would be happy to settle. They just want her to take some responsibility. She never will take any responsibility. She will be playing victim until the end. This is her new identity. And she will be trying to cement this idea that she's a victim into the public consciousness as long as she lives. And this is part of innocence fraud. It's also, as you know, she told Natalie Bernsteiner-Wawicki that she'd gotten rid of all of John O'Keefe's pictures because she couldn't stand to look at his face. She wants to seemingly erase John O'Keefe from off of the face of the earth. And replace herself as the victim in this case. So this is a very unusual pre-trial innocence fraud campaign. Usually I'm talking about campaigns where person gets convicted and how somehow they successfully overturn the case 14 years and later with either podcasts or faux documentaries or books or just a public campaign or all of the above. But this is a rare pretrial innocence fraud campaign, and I think we're going to see a lot more of them now that this was so successful and so lucrative. So that is what I have for today. But I just thought the judge is going to come back with a ruling on this, whether Karen Reed can continue to sue in this court. And it will be interesting to see, I will be watching, if the judge says no. And that will be a minor miracle, I think, because what we've seen so far is just judges allowing all of this really unprecedented nonsense in her case to bring in. I mean, they weren't allowed to argue third party, but they basically argued third party anyway. They were allowed to develop it, but they really argued it anyway. So if the judge allows it, I think it's over for the O'Keefes. I think they should drop their case. If they bring in all these other people, it's over for them. They cannot win with Karen Reed playing fast and loose with the rules, and there's 50 million different people she's suing at the same time that she's also defending herself. It's just going to create too much chaos and confusion. But it's very much like the way Karen Reed has done things since the beginning of this case, if you don't think that Karen Reed plotted out how to get away with this by starting to call people, Catherine Camerano strangely had a very vague memory on the stand as to what Karen Reed told her on the phone. She knew the characters and their weaknesses, and what, the Cameranos seem like people that don't want to put their neck out and stand up for their murdered friend. They rather just go with the flow and say as little as possible and hop off the stand than expose Karen Reed as the psychopath that she is. She knew this. She's a psychopath. She could read these people. She knew the kind of character she wanted to bring in to be able to point the finger at. And that's what she did. We all have human frailties, and they all can be exaggerated and exploited as a distraction tool. And that's how this campaign worked. There was no need to call Jen McCabe. There was no need to involve Kerry Roberts or the Cameranos or Kaylee. All she had to do was call 911. But what happens if she calls 911? She's just there alone. There's no one else to point the finger at. It's just her. It's just Karen Reed. All right. Have a great night, everybody. Thanks so much for listening. And I'll see you back here, I guess, tomorrow at 10 a.m. A special live show, different time tomorrow. I don't rarely do it, but I had to accommodate Brendan Kane's schedule. So we're going to be on live talking about this very hearing with Brendan Kane and what it's like to be on to be with the victims facing this kind of massive innocence fraud campaign. Okay, I hope I'll see you all there tomorrow at 10 a.m. Eastern.